Let's go ahead and get started. My name is Jack Levine. I'm a friend of the cause, and I've been asked to facilitate this conversation, but frankly, the stars are on the stage. We are going to do a 5-minute warm-up, and it's voluntary, but everybody will do it. And that is, we'd like you to please make a new friend. I'd like you to meet somebody who you don't know, where you're from, where you work, and maybe when you came to Florida from where. It's 3 minutes. It's 3 minutes. Make a new friend. It's the honor system, but we have no reason to not trust you. Make a new friend.
I know you from Indiana. You don't know that. You don't know that. We met at graduation.
You guys from Indiana.
Oh, have you? Yeah.
And you guys are in the Medicaid world together.
Somewhat, yeah. I spoke with your buddy Craig Smith yesterday.
Oh, did you really?
You know what they've offered?
Did you meet somebody new? Jack's name.
Fort Pierce.
So you're Burns
No, I work for state office.
state office. Okay, great. Good to see you.
Nice.
Okay, let's settle in. Okay, let's settle in. Okay. Your Honor, I see you. You always call out one name and everybody gets quiet. Calling out a judge, I love it. So why cut into our distinguished panelists' time to ask you to make a new friend? And it was the honor system, but I know a lot of you in here, so I think you obeyed the rules. Because this is about relationships. However you define this, in legal terms, in statutory terms, this is about leveraging who we are and where we've come from and what our experience is for a better good. So I'm not going to keep you from spending more time with your new friend, but that's going to be on your time, not during this session. So thank you very much for agreeing. We have 4 distinguished voices, and I'm going to play a minimalist role. I'm just facilitating. And they're even going to do self-introductions, although I have a great bio on each 4 of them, but we're not going to cut into time on that either. Trust me, they're very distinguished, okay? Very distinguished and great expertise. And we're going to start with Travis Fitcham, who you met earlier, and he will be our opening presenter during the GAL talk. So Travis, you're up.
Great, thank you. I'm Travis Fincham. I'm an attorney in private practice down in Clearwater, Florida. I do special needs law. I do trust administration as well, special needs trust administration. So that's kind of the approach that I bring to all this. And I have to admit that when they said, hey, it's going to be like a TED Talk type thing, I said, oh, what is that? Didn't know that, did I? So after spending many, many hours watching a bunch of these incredible, and I saw Elon Musk just had one the other day, and I got to go look at his. He just had a presentation, and he's one of my heroes and idols. But yeah, how do you compare it with that kind of stuff? I'm talking about special needs trust, though, and I can be passionate about this because it's what I do, and it's a huge issue, and it's a big concern. I just spoke for an hour and 15 minutes on it next door, and we're talking about dealing with people who have been dealt a difficult hand, right? I mean, they are now dependent upon us as taxpayers and as a state for almost everything, to get them raised and to get them out and to get them, to fly the nest. And then we add what has to be almost an insurmountable additional issue, a disability into that. How difficult would that be? How difficult, either one of them by themselves, and you couple them together, and these individuals start at such a huge disadvantage. It must seem to them, and probably to a lot of you who are working day to day with them, as it's just too much here. This person is not going to have all these same opportunities that we have, is not going to maybe be able to flourish. And what we also do as a system, we do a lot of things backwards and a lot of things wrong. And we're in Florida too, by the way. And Florida, and I mentioned this a little bit in the last session, I'm always curious, and I wanted a reputable source, and I said, how good of a job are we doing with this particular population? And I looked at people with intellectual and developmental disabilities, that we know that that's not all we're dealing with. We may be dealing with somebody who had a brain injury or who was abused, has psychological, mental health, so all of those. But just looking at people with intellectual and developmental disabilities, I said, well, how is Florida doing? I knew it wasn't good. I had no idea. Per capita spending, and the University of Colorado in 2015 published a study, it's called State of the States, and it's regarding intellectual and developmental disability, 2015, so pretty recent figures. And they said, what's the average state's per capita spending on individuals with intellectual and developmental disabilities from all sources? Florida was $1.99 per thousand of household income, per income. So $1.99. So then you say, well, I don't even know what that means. Is it good? Is it bad? What do we have to compare it to? So then we compare it to the national average. So all 50 states plus the District of Columbia. So 50 other organization states to compare it to. The national average was $4.53 per person. And we are $1.99. So we're less than half of the average. So then my question was, are we last? Are we worst? And I'm happy to say we're not last. Out of 50 states plus the District of Columbia, we are, though, number 50. 50 out of 50 states plus DC. DC is above us. And not by just a little bit. There are states that are spending $8 and $10 per individual on this, and we're at $1.99. And so I said, well, who's worse? I mean, that's the first thing you say is, who could be worse than that then? And you think if it's a poor state. And so I said, well, who do I think are the poorest states? And I hope I don't offend anybody. I'm going, well, it's got to be in the South, maybe Mississippi, Alabama, West Virginia. No, all of them were well above Florida. All of them well above Florida. Nevada. Sorry if you're from Nevada. That's the only state that spends less on this population. So on top of all of that, if we're saying, well, the government's going to continue to take care of them, it just doesn't happen. The services, and I know Nancy talked about this all day long, are putrid. They're paltry. They're horrible. They're not even substandard. So what can we do? Well, we do a huge disservice by trying to keep people in that system and with nothing else. And so sometimes we're in the dependency system and we're saving, and you got this master trust, a lot of you are probably familiar with it, where their social security check, if they are getting something, can start to get accumulated and saved up a little bit, and that trust is protected for them while they're in the system. But then once they get out, once they age out, we just go, here you go, here it is, you're done. And if it's more than $2,000, they lose even those basic things. They lose the $1.99 of services that they're getting, at that level. And what a huge disservice that is. And so what we want to, and what I want to make sure that you know about and you're aware of, is that there are a couple of options, a couple of alternatives. And one of those is the Special Needs Trust. And again, there's lots of information, you can learn a lot about it, but you need to identify that if this person needs to still maintain those basic benefits, and we want to have a pot of money to then enhance, to give them more than they would have gotten otherwise, then where can I protect it? Can't have more than $2,000 and still get that particular Social Security check through SSI. Can't have more than $2,000 and get that Medicaid waiver program. What can we do with this extra money? Special needs trusts have been around, at least in this area, in this vein, since 1993. They're part of the Federal Social Security Act, so they work, at least today, in Florida to protect these benefits. Whole other story if we start block granting and giving money, Medicaid dollars to the states, and heaven help us if they let the state of Florida set the rules for all this, because they're not doing a very good job taking care of people already, being 50th out of 51. So I think it could be worse. We need to still have the federal government saying, you got to do more. You gotta provide these basic services, these basic abilities. So the Special Needs Trust allows the dollars to be there and allows them to keep those benefits, as paltry as they may be, but then those dollars can enhance. They can give them things they would have never had otherwise. And if you don't shelter it right off the bat, they're going to spend it, or they're going to lose their benefits, and then they got to spend it because they have no home, no place to live, no income, no medical coverage a lot of times. And so the trust can be used to enhance. And then we also have an ABLE account now. And the ABLE account, which I can just make sure I have time, the ABLE account is new. They've only been available in Florida since July of last year, so less than a year, but an ABLE account is a place where we can shelter up to $14,000 per year can go into this ABLE account. Florida's ABLE program is called ABLE United. As of yesterday, in about 10 months worth of activity, there are 888 accounts established under Florida's ABLE program, and they're handling about $3.1 million. It's a lot of money considering 808, so you can figure out what the average is, but 888 accounts, $3.1 million. It's administered by the Florida Prepaid College Board that has over $10 billion, with a B, dollars under management. So they have BlackRock and they have Vanguard managing and handling these funds. I opened up an ABLE account on July 2nd, the second day it was available. That account, with a kind of a moderate portfolio mix, is up 9.83% since July invested. And that money grows tax-free as long as it's used for certain qualifying disability expenses. That's a big deal. And so, and I helped a gentleman who's 66 years of age just this past week open up an account, even though ABLE accounts are required to be open for individuals whose disability occurred prior to age 26. He was born with a disability. We were able to document it, and we opened up an ABLE account. So these are tools. So your young person who's just aging out of the program can help with your help as a guardian or as an advocate to establish one of these accounts, keep those paltry as they may be, but they are benefits in place, and allow these dollars to continue to supplement and add into their life. And that's the idea of the Special Needs Trust. It helps the money be there for the person who needs it the most. Thank you.
Thank you. We're going to hold all questions till our four presenters have their say, so jot yourself some notes and we'll come back to you. Mary Kay Wimsett.
One thing I want to mention that wasn't mentioned this morning about Travis is his trust was mentioned, the Guardian Trust, but that trust helps thousands and thousands, Travis knows the exact number, of disabled folks all over the state. It is a tremendous service to our community and to the disabled folks in our community because, again, it's helping thousands and thousands of disabled people save some money so that they can be eligible for Medicaid or whatever benefits they might need. My name is Mary Kay Wimsett. I've been involved with the program, the Guardian Ad Litem program, now for almost 20 years. In every shape known to man, I've been a volunteer, I've been a program attorney, I've been a supervising attorney, I'm now with the state office. It's weird because I only went to law school like 2 years ago, so I don't know how this has happened. But I also have a private practice where I do adoptions and then some probate. So I'm here to talk to you today about guardianships and whether you need them or not for your youth that are aging out of the dependency system. So I think what I want to first talk about is what a guardianship is, just very generally, that it's a probate proceeding. It is not permanent guardianship. So all of you folks in the dependency world that think permanent guardianship, oh, that's just the judge signing the order, closing the case, permanent guardianship. That is not what we're talking about. Guardianship through the probate court are very complicated legal proceedings that last until the ward dies or has their rights restored. It is a very serious legal proceeding. You're taking away someone's rights. So it is not something that you jump into lightly. Not that we ever jump into permanent guardianship lightly, but I just want to make sure that everyone understands we're talking about apples and oranges here. And the first thing you really need to look at with your youth is if the youth needs a guardianship. You always want to look for a less restrictive alternative. And to figure that out, you've got to first figure out what the youth's needs are, what the youth's issues are. Most people that have a guardianship are either are elderly, they have dementia, Alzheimer's, they need protection, so that's why there's a guardianship, or they're seriously mentally ill, where they have paranoid schizophrenia, or they're disabled. So a teenager that's really bad at making decisions, and trust, I wish Jerry Glenn was in here, because I remember being in one of his presentations probably 10 years ago, and he was talking about his teenagers and how they're insane, and I remember thinking, oh, my children will never be like that. They'll be perfect. But for those of you who have teenagers, their brains are not fully developed, and they are generally not good decision makers. So it'd be nice probably to get guardianships for a lot of teenagers, but, our kids that are bad decision makers are not going to be eligible for a guardianship. So and those are going to be, probably a relatively small population that is going to qualify for a guardianship. I'm not going to there's someone in the room on the spot, in this room, I'm not going to put her on the spot, Katie Boss, who does a lot of ad litem work, but if you look at her caseload, very few of her caseloads actually would meet the legal requirements for a guardianship. But I think she would say that all of them need help when they age out of the foster care system. So you've got to identify what's going on with the kid. Does the kid have a disability? And you need to do that before the child turns 18. I've been helping the University of Florida with a case that's pretty complicated because the department waited and they did not do what they needed to do before the child turned 18. And now everyone said the child's autistic. Well, when we go to look for the medical records, the proof of the autism, we can't find anything. It's in the judicial review, but that's not going to cut it. You need to have a psychological, you need to have some medical determination of this disability, this diagnosis of this disability. That is easy to get in dependency court. Much easier. There's no one to pay for it in the probate world. So you've got to get that in place while you're in dependency court. You're entitled to, under the Regis Little Act, which Alan talked about this morning, the statute that went into effect in 2015 that enables you to file guardianships before a child turns 18. Under that statute, the child's entitled to a face-to-face meeting, a case plan conference, that's a multidisciplinary staffing. So if you show up at the staffing and the staffing is you and CLS and a caseworker, that's not a multidisciplinary staffing. You need to require the department to get the people at the table who can help you make decisions about what is needed in the child's life. Teachers, psychologists, you need to go, if they don't have that information, if they don't have a child study, they don't have a psychological, you need to make the department get that information so that you can have a quality staffing and you can make a determination as to what is best for that child. So if that child needs help, but you're not going to have enough to get to a guardianship, what do you do? Florida has 3 advanced directives. They are a durable power of attorney, a healthcare surrogate, and a living will. If you don't have those and you're an attorney, shame on you. Everyone needs those 3 documents. Durable power of attorney, Travis is probably making faces behind me, but a durable power of attorney is a document that whoever you indicate, it enables them to handle your financial affairs. The healthcare surrogate is a document that enables whoever you indicate to handle your healthcare decisions, placement, anything related to your healthcare. And then the living will, of course, is a document that enables your healthcare surrogate to make end-of-life decisions for you. If you don't have those documents and you become incapacitated in a car accident, a stroke, something happens to you, there's no one to make, your loved ones are left with no choice but to get a guardianship at that point. But you can get those documents in place, and a lot of attorneys will do them pro bono for your kids, I'm sure. If you're in the 8th Circuit, I definitely will. You can get those documents in place. They're not complicated legal documents. The child does not have to understand every intricacy of the power of attorney. A good power of attorney is going to have tax information, it's going to have information about applying for Social Security, it's going to have all kinds of information that honestly most people don't understand. So your 18-year-old youth is not expected to understand it to that level, but they need to understand what they're doing essentially, that they're giving someone else the ability to help them with their affairs. It's a very powerful, power of attorney is a very powerful document because you can use that document to handle a bank account, you can use it to you can deal with financial institutions, again, anything financial in that youth's life, you can use that power of attorney. So, which gets us to who is going to be that person? Who's going to be the agent or who's going to be the guardian? And that's also a conversation that needs to start really early in the process. There may be folks that are involved in the child's life, teachers, former mentors, that weren't able to accept placement, but that are willing to step up and either have power of attorney or willing to serve as the guardian. So again, that's why you have to start early. You have to start those discussions early. I was trying not to use my notes, but I want to make sure I don't forget anything with you guys. The other thing you can do is you can designate a rep payee. So, and that's something that I think a lot of people don't realize. So if a child's on Social Security, when they're 18, they can go to Social Security and they can designate who they want to be the rep payee. It can be their attorney, in fact, through their power of attorney. It can also be their group home. I have a client where her group home is the rep payee. They take out their payment every month, and then she gets a small allowance every month to spend how she sees fit. But that can be another way where you're not just giving the child unrestricted access to a large amount of money. There can be some added protections in there if you're not able to get a guardianship. So let's talk about who can be. If you need a guardian, who can be the guardian? That person does not have to live in the same county where the youth lives. You have to file the guardianship where the youth lives, so keep that in mind. So if you have a youth that's trying to decide where they want to live when they turn 18, you need to nail them down on where they're going to live, because that's where you have to file the guardianship, and it's a pain to move it county to county. So then if you've got a person that's identified to be the guardian, then you need to figure out if they're going to qualify. They have to have no felonies. They cannot have any prior abuse verifications. There's an educational requirement. They're going to have to take a certain number of, they're going to have to watch a video. It's usually, or it's a class. It depends. It varies circuit by circuit how they do it. There's an application they have to fill out. So it is, it is an onerous process. There is a public guardian. They did get an increase in funding with the Regis Little Act, but I think they already now have a tremendous wait list again. But it's worth exploring. It's my understanding it varies circuit by circuit, so it's worth reaching out to your public guardian, finding out how you get on their wait list, especially if you're doing that early planning. When the child is 16, find out, can I go ahead and, we're gonna need a guardian when he's 18. Can I go ahead and get him on the waiting list, or how does this work? There are volunteers, too, in some areas that will serve as the guardians. I know, for example, in our circuit, Takachali, which is a residential placement for handicapped individuals, they have a list of folks that are willing to be volunteers. So that's another, if you can find a facility in your area that has a lot of incapacitated adults, they may also have some access to volunteers. But that's going to be, honestly, that's going to be the hardest part in this process, most likely, is finding an adult that's willing to be the guardian, because they have to stay on the guardianship until the youth dies or the guardianship's terminated. So it's a huge responsibility. Okay, let's talk about the two types of guardianships real quick. How much time do I have? I have 3 minutes, oh gosh. Okay, guardian advocacies and guardianships. I'm gonna talk about guardian advocacies because that is what you are gonna most likely utilize. A guardianship requires an examining committee, that is a doctor, a nurse, social worker, or a psychologist, a group of 3 individuals that have to examine the person. It can be a very debilitating experience for the youth. Then they have to be found incapacitated by the court. You really want to avoid a full-blown guardianship if you can. So how you can do that is with a guardian advocacy. But to get a guardian advocacy, you've got to have a disability. So, and the disabilities are specifically listed in the statute. I'm going to run through them real quick, but you can also email me, and I'm happy to send you the exact language. But autism, Prader-Willi, CP, Down syndrome, spina bifida, Phelan, McDermott, and then an IQ under 70. So that's where most of us are probably going to be able to get that guardian advocacy potentially. Or the autism diagnosis is pretty prevalent these days too. I see that in a lot of our kids. So, but again, you've got to have that diagnosis before the child is 18, and you've got to have that documented. The great thing about a guardian advocacy as well is that it's less onerous, it's quicker, much quicker than a full-blown guardianship. You don't actually have to have an attorney file it. You guys, your volunteers, your guardian ad litem volunteers they could help fill out the paperwork if there's a grandmother or whoever's willing to be the guardian. It's not a difficult legal process. There's pro se clinics and many circuits that will help fill out the paperwork. For a full-blown guardianship, you have to have an attorney. The youth is represented by an attorney, so if there are ad litems in here, keep that in mind. You can actually get paid by the JAC. A lot of people don't know this. And there's an excellent video on our website that I think Nancy did about getting paid by the JAC. So there's ways you can get paid by the JAC for acting as an ad litem post 18. So it's important to utilize that and use that because no one's using that money. So we want you guys to really be doing that. Okay, I know I'm out of time. I've got 1 more minute. Okay, so I shouldn't have asked because now I lost my rhythm. And I know I talk so fast. I just have so much information that I want to give you guys. I do want to encourage you, the guardian ad litems. I know a lot of you ask me adoption questions, but I'm also happy anytime to help with the probate issues and help you guys assess whether you think guardianship would be a good option. The rights that and one thing I should mention about guardianships is they don't have to be all or nothing. So, and the rights that a guardianship, and I know I'll put the mic up back to my mouth. Let me find my card. The rights that the guardianship can limit are the right to marry, the right to vote, the right to apply for government benefits, the right to drive, the right to travel, the right to seek or obtain or maintain employment, to sue or be sued, to contract, to manage or give property, or to consent to medical treatment, to determine residence or decisions about social environment. So you often have, especially in youth, you probably are going to have a hybrid where they might be able to vote. You might want to let them, work. But you want to make sure they don't get married, or you want to make sure that they're living in an appropriate setting. So the guardianship can be limited. It doesn't have to be a full plenary guardianship. But again, remember, with that guardianship, you're going to have to find that finding of incapacity by that examining committee, which is probably going to be pretty difficult with most of our youth. You're most likely going to go with either them having a disability, or you're going to look at one of the less restrictive options.
So, hi, I'm Nancy Wright. I'm not used to being higher than most people, so I'm just gonna stay where I am. I get dizzy up there. I'm in private practice. I spent some time as a guardian ad litem. Kind of as my foray back into the legal world. I took some time off and raised little humans, and prior to that, I did environmental law. And then I decided that I kind of liked it, and worked at a legal aid for a while, and through weird circumstances I ended up getting involved in a big Medicaid, particularly an APD grant-funded advocacy, and I loved it because I have some sort of brain anomaly that makes me really like super incomprehensible sets of law. So I went from environmental law to Medicaid, and I don't know. There's nowhere else to go. That's kind of the preeminent confusion is Medicaid. But mostly because I just loved working with the clients. I loved the caregivers, and I've always felt like they represent to me people that I want to be like, and I love working with the clients themselves. So I went into private practice, and I am like one of the only humans on the planet that does Medicaid in private practice. I work out of my home. I have real low overhead. So my topic was transition and the Medicaid waiver, and as a result, that actually kind of segues nicely with Mary Kay's, because we're talking about those groups of kids that you have that would meet the same requirements for a guardian advocacy. So those are kids that have an IQ of 70 or under, or have a relatively severe form of autism. Actually, there's a spectrum. And then the other diagnoses that she talked about, including cerebral palsy. And as we saw from our keynote speaker, you don't have to have an intellectual disability to meet the criteria for this program, and many people do not. So I think that that's sometimes overlooked by people. They think that if you're on the Medicaid waiver, then you must have an intellectual disability, and that's definitely not true. When I looked at the topic, I tried to think, what is TED talking about this? Because I wasn't feeling it, So here's what I think is TED talking about this, at least for me, is I want us to really look at the transition process. And I've been involved in it from many aspects, including I do work as a special education attorney, so I get to see it from that aspect as well. And here's what the list, this is why I have to sit down because I have my list. Everybody that's part of this process they all agree, right? It's a critical time. You know, you want to do whatever's best to help that person reach their full potential. But here are all the people that have to be involved. So you got DCF, and they're either doing extended foster care if that's appropriate, or you got your whole cast of characters. You know, the court, the attorney ad litem, the CBC case manager, the DCF CLS person. And then you've got the guardian ad litem program, and then you've got the school, and the school transition process is supposed to start when they're 14 years old. So, you know, ostensibly that's been going on for a while. Then you got the DJJ if they're involved, and then you've got now managed care programs, and that would include mostly Sunshine Health for a lot of these kids. And also for some of these kids, you might have CMS involved, and they've got case managers, and you probably didn't know it, but under the contract with the Agency for Healthcare Administration, those case managers are responsible for transitioning. You might not even know who those case managers are, but supposedly they're out there thinking about it, you know. Then you've got vocational rehabilitation. So that's actually a program that has got some bucks. They can do some shit, you know. Oops, sorry. But they can. They can do. I'm sorry, I didn't say that. They actually have some great programs for people. They can help them go to college even sometimes. I mean, it's really cool stuff. But if you call them about transitioning, I've actually had them say they don't get involved when the kid's in school. I had to point out to them, they have on their insert word here, website, oh look, it's called Transition Youth Program from age 15 to 21. I made them look at their own website, and they finally got somebody involved in transition. That's a tactic you may use again. I will not charge you for that. And then if you've got a child that is eligible for APD's program, you've got them involved, and they should at some point have a support coordinator who's also engaging in that process. So let's see, who have we left out? Okay, one group of people we've left out are the people that see these kids day in, day out, the people who are providers, who provide therapies. They're psychologists, they're social workers, they're teachers, they're foster families, they're families if they're still part of that process. Those people are often not engaged in this at all or minimally. And then you have, let's see, who's left? Oh, wait a minute, the kid. We so rarely pay attention to what the kid wants. We're all, and I see this all the time in IEP meetings. Has anyone ever been to those with a lawyer? They get 20 people in the room, you know, that is meant to hold 5. And you're sitting in these teeny little, you know, chairs that are 2 feet from the ground. It's a mess. And the only way to handle it is what I'm going to tell you now, is to repeatedly go back to the kid. You cannot let these huge groups of people that are all have their assumptions, they all have their agendas, they all have their pot of money that they're trying to protect. You cannot let them, you've got to have at least one person in the room that keeps coming back to the kid. What does the kid need? And you cannot make assumptions about that. And it's not just going to be asking the kid. I have a case right now where the school system, she's got an intellectual disability, and she's charming as can be and got great social skills. She is failing everything and feels crappy about herself. And when you ask her what she wants to do and what she wants to be, what her transition would be, she wants to go to Princeton and she wants to be a doctor. And those are wonderful goals, but why does she want to go to Princeton? What is it about being a doctor that she likes? No one explored it. Instead, the school wants to just keep her failing day in and day out based on this absurd notion that she has any idea what she's saying when she says she wants to go to Princeton and be a doctor. You know, when I talked to her for 15 minutes, she doesn't know what college is, what it means, what it entails, but she had a relative that went there and said it was a pretty place. And she wants to work in a nursing home. She wants to work with people, with the old elderly, because she loves working with them. Well, fine. There's ways to help her do that, but not by making her fail in school every day so that she hates herself. Another example was a group of very well-intentioned people who put together a whole farm for their children who were autistic, and the deal was that on transition they were going to grow vegetables and get paid for it. And I sat with a group of providers and discovered that at least one of those girls hates the outdoors and just freaks out when she gets dirt on her. It was the absolute worst thing for her to do. And we can all have good intentions, and I know we do. I go in every meeting knowing that the people around me have good intentions. But those intentions have to be married with an open mind and an active effort to try to both know your kid and know what options are out there for your kid. Now, in terms of options, that's probably why we're all here. Like, what options do we actually have? They're out there. I think that, and I agree, Travis, this state is definitely low down on the list. We don't pay enough. We particularly don't pay enough to providers. Providers are dropping out of Medicaid programs at rapid numbers. You can't even find nurses often to do Medicaid work. I can't fix that with this, but I can tell you that for children at least, I have seen really exceptional things happen with effective advocacy. And what I see all the time is that we have the ingredients, we could make a great cake with them, but what ends up happening is, a stale bologna sandwich is all we get. And most of it is because of what I see as infighting among the agencies and an inability of the agencies to get along. So let me ask you, has anyone here ever heard of the interagency agreement between ACA, APD, DCF, DJJ, Department of Education, Department of Health, and the Guardian Ad Litem program? Does anyone raise your hand if you've heard of it? Okay. Has anyone ever used this? Okay. That's what I thought. So there exists in this world and on the internet, if you search really hard for it, by the way, an interagency agreement. Now, the one that I have in my hand was actually signed in 2012, and it's good until July 1st, 2017. And the whole function of it, with all of these agencies, is to deal with children, particularly children who need multiple services from multiple agencies. Does anyone have children like that they deal with? Okay, all of us, especially kids with developmental disabilities. And the whole purpose of this is to have review teams that are on a local, regional, and state level that work out disagreements and details about what services this person needs and which agencies are supposed to be handling it. It's supposed to be in a revision, because I emailed the general counsel for APD and ACA to say, what is this? And I was told that this is in revision. I don't know how they're going to revise it. My suggestion is, and it's not in this agreement, is that if everyone knows the child needs a service, somebody give the child the damn service and then fight about it amongst yourselves later on as to which agency is going to pay for it. How many of you have waited months and months and months while agencies make their play with each other to figure out who's responsible? I think that has to end. And what I would suggest is if you're going to do this revisions to the agreement, they put a binding arbitration clause in it. Give the kid what the kid needs, and then have all the agency lawyers get to go to binding arbitration and have someone decide how to do that. Is that it? Am I up for my, are you just thanking me? Am I up? Okay. I didn't talk at all about what APD offers, and they have some good stuff.
And Nancy's presenting. Hi, I'm Patty Profiter, and I am the statewide continuing education coordinator for the Guardian Ad Litem program. I've been in the dependency system in Florida since 2001, between DCF and Guardian Ad Litem, trial counsel, appellate counsel for both agencies, and a couple of other different things in between. So I've been around for a long time. However, prior to becoming a lawyer, I was a special educator. And back when I graduated from college, they actually had certifications, and they were specific. And so I was certified to teach what we called then mentally retarded children, specific learning disabled children, and emotionally handicapped / severely emotionally disturbed children. And so that's what I did before I went to law school. And I taught in several different states. And the reason that I ended up going to law school, and specifically going to law school to work with abused and neglected children, was because the vast majority of my students came from homes where if they had not been removed, they should have been removed. Now there is a caveat there. Because I was certified to work with the severely emotionally disturbed and emotionally handicapped kids, those were the jobs I got because nobody else wanted to do that. So most of the kids that I saw were emotionally handicapped, and those are the families that I'm talking about. But that's what led me to do advocacy work on behalf of abused children. And although I am no longer teaching special ed, that still has been a factor that keeps me in the system. Now, when I was asked to talk today, I struggled a bit because I knew there's no way that I could do a good job of talking about all the laws, all the state laws, the federal laws that are in place to help our young adults that are aging out of foster care on their path to education. And there's a lot of information out there. Luckily, I don't have to, because at this workshop, this conference, there are numerous workshops that deal specifically with many of the issues that I'm going to touch on. So I encourage you to go and see as many of those as you can. The ones that you can't, they're all being recorded, and they're going to be available for you to view. Also, as Nancy mentioned, the internet is full of resources that I looked into in order to prepare for this, and I was amazed at how much information is out there. So, if you are looking for information on children that you're working with or young adults, that's a great place to start. And for Florida, the best place to start would be what's called the Florida Independent Living Resource Center. It's on DCF's website. It's fairly new. It was created in 2016, and it is it's an information clearinghouse, all kinds of information. And of course, its objective is to assist the youth with obtaining life skills and education necessary to become self-sufficient, live independently, and maintain employment. So at this point, I probably don't need to speak anymore because I've told you where to go to find information. But actually, I still want to talk to you because what I really want to talk about has to do with our mindset when we are serving young adults in our system. Because this is the mindset where, up to this point, our involvement with the children and the young adults and their involvement with us is generally us telling them, these are the options, this is what you have to do. Sorry, you don't fit into this, you don't qualify for this, you can't do that. For us, at this point, when they are transitioning into adulthood, and if that's including post-secondary education, it may be the first time that we're able to say, hey, what do you want to do? What are your goals? What are your aspirations? I can help you with those. And so we're really in a good point, but we have to change our mindset, and we have to change it in such a way that the kids know that it's changing, because otherwise they're not going to engage with us. Even though there are some good opportunities. I know Florida's not great, but we do have some good opportunities for them. At least it's a starting point. But they're not going to even want to talk to us about PES or extended foster care or even the aftercare services if they don't have the kind of relationship with us where our mindset is, what do you want to do and let me help you? So I'm here to talk to you about that. And again, obviously we still have to deal with the options that are out there, and we have to deal with the services that do exist and that we can take advantage of. But if we can slowly change the mindset, then we're going to have kids who come to us because they want to be helped, and they want when they transition into adulthood. Okay, so this mindset and how we need to get it started is one of the things that we need to really start thinking about. Is instead of the way we tend to handle all the children in the dependency system, is we have to start having a conversation with the children, and the child needs to be the focus. Because if you think about it, up to this point, the focus has been on the parents and what they did wrong and what they need to do to fix it in order to get their children back. It's not really been on the children, where we're saying, okay, what do you want to do? What do you want to be when you grow up? So let's talk about that. So that's what I hope all of us can do if we have children that are, they don't have to be, I'm not talking about just the ones that are 17 and a half and that are about to age out. I'm talking about the kids that are 13. Possibly even younger. This type of conversation where we're talking about their future should always be driven with, what do you want, and let me see what I can do to help you. Now, the child that wants to go to Princeton to be a doctor and that's never going to happen, that's okay. Because once you knew what she wanted and why she wanted it, you were able to work something out that actually worked out perfectly for her. And I heard another story about someone who wanted to, I think, be a veterinarian, and it was the same issue. There were cognitive impairments. He was never going to be able to go to vet school, but he ended up working at a shelter, I think, was for animals. So start the conversation early. Make sure it's a conversation and not a court order or a checklist of services that you may or may not qualify for, or that the caseworker is able to check off and say, okay, I've done this, I gave them the pamphlet, now I'm done. It needs to be a conversation, it needs to be an ongoing conversation. Next question might be, well, when does this conversation start? I don't know. It depends. It depends on the child. It depends on where they are in the system. It depends on their age. It depends on basically what has happened in their dependency case, and it depends on their answers to your questions. What do they want to do? Well, if they know early enough what they think they want to do, then we can start talking. We can start having that conversation earlier rather than later, so that we can start putting special services and tasks in their, say, their case plan when they're 13 years old. Okay, I mentioned 13 not because that is a magic number, but because the statute, Chapter 39, requires that at age 13 that there are services that are pre-independent living services. So that's why I mentioned at least at 13. In my opinion, and based on my background in special education, I think that for the kids that are at least in the dependency system and have a disability, when we're at those IEP meetings, that's when the conversation should be starting. Yes, they are only in 7th grade. And for the most part, at least all of the IEP meetings that I sat through, the goal was to get through the year. Well, for my kids, it was to get through the week. But generally, you had a goal, and it was to get through the year, and nobody was really thinking about the year after that. And that's where we also need to change it so that our conversation, which is including the child, is geared towards their future and not just so that we can, again, check off box because we've achieved a goal and we have some kind of objective measurement to show that we've completed that task. Okay, so at age 13, we've got the case plan. And yes, that's when we can start working through that. However, as the children are growing up, then their needs are going to grow up, and they're going to have an even better sense of what it is that they want to do when they grow up. Okay, and if our conversation is continuing as it should, then we need to, we're going to have to be changing some of our services and some of those tasks that the children are going to need, or the young adults are going to need, in order to achieve their goals and their desired outcomes. Florida has done a great thing with the normalcy statute, because one of the things that that has been sorely missing in our foster care system is the ability for the children in care to be able to do what we consider normal activities, sleepovers, going to Disney World, going on summer vacations, engaging in after-school activities, joining the band, all kinds of different types of activities that it literally would take a court order before the caregiver was able to give permission for the child to do this. Under the normalcy statute, as long as the caregiver is using the reasonable, prudent parent standard, they can now agree and allow the children in their care to do these things without court order. And that is huge. And it's not just huge because it's great for the kids, it's also huge for their post-secondary education. How many of you have kids that are in college or are applying for college? All the things that you have to do in order to be accepted at a college, whether you have disabilities or not, it's overwhelming. And the more well-rounded you are, the better applicant that you are in order for them to accept you into their program. So when you have kids that are in the foster care system, with or without disabilities, before the normalcy statute, they had very little opportunity to actually become this well-rounded young adult that could write a good college essay about some experience that they had, because the opportunities simply weren't there. As you heard Alan talk about earlier, or I think it was Kelly, the keys to independence that Governor Scott just signed, that's a big advantage for our kids, because as they get older, even older than the 13 and 14-year-olds, if they can drive, that means they can have part-time jobs, or they can have internships, or they can do numerous things that are going to help them, again, be well-rounded adults, but also help them get into college. Am I done? Oh, okay, I'm done. I'm sorry. One thing I want to add is, if you are working with kids and they have an IEP because they have a disability, please start dealing with post-secondary education during the IEP meetings, the case plans, and then when they get to the transition plan at age 17. All of those goals should be correlated and working together. Thank you.
Wow, wow. A wonderful foursome, and we're not done yet. If you do not know about a network called Florida Reach, you can Google Florida Reach. There are about 150 of us now that are engaged in the conversation about youth transitions from care to higher ed and other life opportunities. We have many K through 12 districts, state colleges, universities, provider networks, GALs. So Florida Reach, and we can get you enrolled. It's very easy. We have a monthly call. We run a conference. So stay tuned for that. And it's soon to be announced. You're getting the scoop that it will be administered by Educate Tomorrow outside of Miami for a statewide set of services. So you came to this conference, paid a little registration fee, and got a big scoop. So we're going to turn this mic over to you. I'm going to start the question as an icebreaker to ask each of you 15 seconds each to answer this question. Single greatest challenge. See what Mary Kay did? She just passed the microphone over. She's crafty. Single greatest challenge, single greatest opportunity from your perspective. I know you touched on that, but single greatest challenge, single greatest opportunity. Patty, you're up.
So, I mean, this is an easy one. The single greatest challenge, I think, is resources. We all know what we want for our kids, but finding those resources and putting them in place. And then, of course, I think the reward is obvious. It's once you figure out a plan. Like I was thinking about the special needs trust that Travis does, and I was thinking about a client that I have that I've had a very long time in the dependency system. She'll never be adopted. She's going to age out in foster care, severely disabled. We were able to set up a special needs trust for her when she was very young. She's now 16. She has almost $50,000 that we've been able to save because I do fee waivers. We're moving her master trust money into that special needs trust on a regular basis. Instead of letting the department keep all that money, we're moving it over, and she is going to age out into an APD home and have a pretty good chunk to buy a van, to do something that really can make an impact in her life.
Thank you. Travis.
Without repeating things, I think that is one. I think the single greatest challenge, and I'm going to steal this from a good friend of mine, is getting people to do their jobs. There are things there, and you just have to tell them sometimes what their job is. Like Nancy said, it's on your website. And so the other thing is how do you address it is knowledge and coming to things like this, learning, meeting people, knowing resources. I'm going to pick on Nancy. She answers my questions. She helps me. She directs me into the right areas where I can get the answers. And knowledge is power. And you just got to squeak. You got to be that squeaky wheel, and you got to tell people, no, this is your responsibility. This is why you exist, at least in the workforce, to do this. Do your job.
Thank you, Travis. Nancy, tell us what you really think.
Without expletives.
Yes, I can't do it without expletives. I think personally, for me, the greatest challenge is dealing with my own frustrations and the slowness of the system and the blockades and obstacles that I see, because I'm a fixer and I see what I want and I want it fixed, not tomorrow, but right now. And then along with that is getting over my own assumptions that people are trying to personally block me. When I understand that the system itself is frustrating for everybody. There's not a single person in here, regardless of whether you're with an agency or the guardian ad litem program, that isn't experiencing that level of frustration. And probably because resources are so limited, you're taking a too small pool of money and spreading it over too many people. And the parts that I really, really enjoy, though, are all of the times that I deal with people and I'm able to drop that assumption and I'm able to really connect, and then together we're able to actually find solutions.
Thank you. Patty.
Thank you. Now that I have some context, I think that one of my greatest frustrations and challenges in all of the work that I've been doing since, as an adult, is that I do think there are resources out there. I know there are resources, and it's a matter of collaborating and working together and making sure that we can get the money. There's a lot of money out there that should be spent on our kids. Be it the kids in foster care, the kids that have disabilities, and it just seems to be such a hot mess at all times up here that we can't get it to where it should be, and we could have a seamless system, and we should. And that's always been a frustration for me. What makes it better is when things start to work, when they do things like the normalcy statute, the keys to independence, when finally we can get through and work together and get a system in place that's going to help the kids.
Thank you. Our first question is from our William Gladstone Award winner.
This is actually more of a comment. Yes, thank you. He's asking me to rise. We always have to listen to Jack Levine. All right, this is more of a comment, really, and I echo all of the suggestions and greatest challenges and opportunities, because what I see in the courtroom many times is a lack of communication, a lack of collaboration, but I think that's also our greatest opportunity when we can get to the point and realize that if we just start talking to one another, including the attorneys ad litem in the meetings, asking for input, thinking outside of the box, let's think creatively, what other potential solutions are out there? I know, from the judicial perspective, I can't always order certain things, I don't have authority to do certain things, but just making a point to the parties that you all need to come together, you all need to communicate, you all need to think creatively, I think helps a lot.
Thank you. Any response from the panel? Agreed?
Yeah.
All thumbs up? Great. Who's next? Yes, please. Would you rise and identify yourself?
I'm Pamela Bress. I'm an attorney ad litem on the Special Needs Registry, and I find the biggest problem is finding guardian ad litems. I agree 100% with everything that was said. Not guardian ad litems, guardian advocates, excuse me. I cannot sleep at night, and I'm not kidding, because I have a handful of young adults, and I started pre-18, and I still have them 21 22. It brings me to tears. I can't find people. Where are we finding these people? I am going to the community and begging people that I meet, will you become a guardian advocate? Am I missing something? Because they're not there. I've been trying.
I mean, it's a huge problem. I know that apartment, and they're actually presenting right now, I think next door, but Deborah Schroth with CLS, and there's a work group at the department. They're supposed to be working on this issue. I mean, again, I don't know if you've contacted your public guardian. Yeah. The department, though, is really supposed to be helping to find the folks pre-18. So, it sounds like you're doing everything you can on your end as the advocate for the child. So what you might want to do is look for strategies if you're not going to be able to get that guardian, using some of those other strategies so there are some protections for the child. So, with the rep payee, at least their funds then are protected. Or, the power of attorney, again, you can do a lot with the power of attorney. Who will do that,
the power
right?
of attorney? It all comes. I'm not.
Yeah.
I'm just saying. I am the one connector for these kids that bounce from place to place. Every single one of my special needs has been moved so many times from a lockdown residential facility. We grow together to the specialized therapeutic into the regular home. Not anywhere along that trail is there someone willing to sign on a document. And I'm an attorney, so I can't
Right.
be the attorney.
Well, I was going to say, and don't,
Yeah.
speaking from personal experience, don't do it. You're going to be tempted, but they will. But, the one thing, too, I will say, in cases like that I've had, where I've had some success, I think, is where I've been able to find a group home that I felt comfortable with, and then the group home owner was willing to take on that responsibility and essentially step into that role. So, I would encourage you to keep trying to find those folks potentially. And then I'll tell you, I looked in the description of the one they're presenting next door, they said that they're going to provide resources for potential guardians. And I looked in their materials and I didn't see that, but I'm going to follow up with them, and I'll be happy to, if you want to email me, I'll be happy to see, and tell me where you are, because that would help too. I'll give you I'll come up after.
I'm Deborah Lacombe. I work at the statewide office, and this is a problem that is, I think everyone in the room recognizes, and it has been a priority for our program. And I know the reason that I wanted the microphone is that earlier this year, we attempted to get all the big wigs at DCF and Elder Affairs and everybody around a table. And we were faced with a lot of the miscommunication and pass the buck kind of thing that has characterized this issue for a long time. The reason that I wanted to talk was that one of the things that I learned is evidently some of the counties have taken on, the responsibility of providing money for guardians, and so the county may be a resource for you, but I also wanted to encourage you to get a copy of the interagency agreement, because there were a couple of sort of side discussions where people said, boy, I was able to get to the secretary of XYZ as a result of that interagency agreement, and then I got some action. So it may be that could be, a resource that you may be able to use.
Just a storm warning, the legislature is passing a constitutional amendment for the voters in 2018 to increase the homestead exemption. That will cut into resources available for special programs in the counties, just so you know. That does not come cheap or free or easy. That was an unpaid political announcement. Any questions from the expensive seats? What? Shy? Come on. Yes, please. Please identify yourself into the mic.
My name is Jessica Sweeterman. I'm with the Office of the Attorney General in the 13th Circuit. My question is about the ABLE Trust. Are those able to be, are you able to set them up prior to a child turning 18, or do you have to wait?
It's a great question. The first thing with a clarification is the ABLEs are accounts. There's not actually a trust document. I know what you mean, but I just want to clarify, because I mentioned that at the program earlier, because a lot of people think that there's some master document, and there isn't. It's like a bank account. It's just you can't go to any bank and do it. Short answer is it's any person, and it can be a minor. My daughter was 12 when I opened hers on July 2nd. So you can be any age, and I had a guy 66. The issue is that disability has to have occurred prior to age 26, but you don't have to have been on disability or Social Security didn't have to make a determination that you were disabled. My daughter's never been determined disabled by Social Security. She's now 13. So you just have to allege it, and you have to show, in her particular case, I just had to put a pediatrician's name, and I don't think they called our doctor, that said who diagnosed her with her condition. I said, well, pediatrician did the second she was born. So that's all, and there's nobody following up on it anyway. It's well, it is, and Able United will be the first to tell you, it's self-certification. You're saying it, because what if you're wrong? If you're wrong, it doesn't give you benefits. It just excludes dollars, so then when you go and apply, you can say, I got money in an Able account, and it's excluded. So it doesn't open any programs necessarily for you. It's necessary. You still have to prove, when you go apply for benefits, that you meet the eligibility, and then they'll probably look at it at that point. The risk you run is it maybe doesn't grow tax-free if you're not really disabled. But other than that, it's self-verifying. So any age.
Just for clarification, Travis, Able United is that bank, correct? How do you define
It's not a
that?
bank. It's Florida's program. It's just the
Yes.
name that Florida chose.
Right.
It's actually through the Florida Prepaid College Board. So
Right.
you can there's only one in Florida. It's run by the state, and you open it. It's called Able United, and their website is ableunited.com. So
Right.
that's where
And
you open
to make
accounts.
sure, Able Trust is a completely different entity that actually acts as a foundation.
Able Trust is something totally different. That's correct. There is an Able Trust out there, and
Okay, just to make
that's
sure-
probably a trademark type thing, because it's Able. It's an organization called Able, which
Right,
has
just
nothing
to
to
make
do
sure we're
with
not
achieving a
stumbling.
better
Okay.
life experience. Able accounts.
Great. Are you satisfied? Thank you. Other questions from the floor? This is your time. Yes, sir. Would you rise if you're able?
Gerald Stevens, attorney for the Agency for Persons with Disabilities. Nancy, you were mentioning before that the agency has many wonderful things they can
Oh,
offer.
God,
Could
I
you
knew
take
you
a
were
time
gonna-
to say what those are, please?
So, thank you for that opportunity, Jerry. So the transition tools that you can look to that APD can provide is, first of all, the services that are offered through that organization are geared specifically for people with developmental disabilities. So there are things like specialized mental health therapies that are by therapists who understand intellectual disabilities. There are meaningful day activities, and those include adult day training, which are a whole variety of programs. You have to be careful about which ones fit which person and go to the different ADT programs and scope them out. Some of them offer work opportunities or volunteer opportunities or different kinds of trainings. There are companion services that can help people if they want to go out and do volunteering. I know with my kids, they had no idea, even now, some of them have no idea what they really want to be, and they're in their 20s. I mean, they had a lot of volunteer opportunities. And I think you can expect that the same thing will be true of people, even if they have developmental disabilities. You're not going to go into transition and decide for that person they want to be a nurse, they want to work in an animal shelter. They may make, many other choices throughout their lives, but give them opportunities. So a companion is one way to do that. There is a supported employment program. In order to take advantage of it, you have to use VOC Rehab first, or exhaust that benefit. So if VOC Rehab benefits, they either feel like they can't work with that person, or they work with that person and to the end of their limits, then APD can offer their supported employment services as well. And that includes people sometimes coming to the job with you, helping you navigate that system. So they're definitely good things to look at. You can talk to the support coordinator about them. Most of them are pretty knowledgeable, but do your own research too, because sometimes they're not.
Thank you, Nancy. Is there another question from the floor before we ask our panel members to give their closing statements? Time for one more. That pressing question that's on your mind. Whoops, here we go. Would you use the mic, please?
Hi, I'm Barbara Glass, and I'm an attorney at Lightham also. And I was thinking when you were saying your most frustrating issues, my frustration is that almost all the teens that I've dealt with have not gone into extended foster care and have not taken advantage of the different services that have been available. Now, I didn't get into their life until a year and a half ago or 2 years ago, so maybe I could have coached it better. But I have had a lot of kids that I've dealt with 71 and 72 IQs who have some extreme disabilities, either mental health disabilities and learning disabilities, but still don't qualify for APD or guardian advocacy as a guardianship. And if I was going to be their attorney ad litem, they don't want it. And so I have to stand up in court and say, no, they don't want this, because I have to represent what they want. So what do you say about people who don't quite get those extreme services?
So those to me are definitely the hardest cases. Now I will say that I have gotten people onto the long-term care waiver program having a low IQ that APD didn't accept, but it was sufficiently low so that could clearly show they needed an institutional level of care. They would not be safe without having other types of care available to them. That doesn't give you a place. Like APD's having a group home facility is absolutely necessary for so many of these people who don't have a place to live, except that there's a possibility of using an adult family home or even an assisted living facility if they get supportive services as well. And there are some assisted living facilities that, rather than just deal with people who are elderly, also take in people who have developmental disabilities. So those are possibilities. I frankly have not found that it's that difficult to get a guardian advocacy for someone who's slightly above on the IQ level, as long as the court thinks that person lacks these decision-making skills. They're not as irritating about that 70 cutoff if it's clear that is an appropriate process for that person.
Some people with disabilities who are seeking to get into careers or jobs are eligible for vocational rehabilitation. And I think in some places or states they've actually paid for college education or even law school. Do you think in Florida that would be a good or possible prospect for educational funding?
Oh, I definitely think that people need to look at voc rehab in the transition process, even at school. That they have, I know personally of people who've had college funding paid for through voc rehab, through Florida voc rehab, and most of the funds is federal anyway, I think.
Thank you. As we close, 1 minute per. 1 minute per. Last call. 1 minute per.
I just want to add that I have put together a list of resources that I accumulated while I was looking this up. That will be available on the website when everything else is posted.
Mary Kay?
You can find me on the internet. That sounds worse than I mean it, but and I'm happy to answer any questions that you have.
And likewise, emails and whatever for questions. I'm happy to help. I would just say keep doing what you're doing, but keep adding to what you're doing. The more information, the more knowledge, the more relationships. You should know, if you're dealing a lot with APD, you should shake the hand of the APD legal counsel person if you see them. Get to know people, because if you're dealing with them in the future, to put a face with the name can be very helpful. And you have a common ground. You have something common that you're all here together. So that's awesome.
Nancy?
So what Travis said, because I mean most of the best things I do are because I talked to somebody who gave me a great idea. And even though I work alone in my home, I am constantly in contact with advocates all over the state, annoying the crap out of. Oh, I said it again.
Well,
that sounds bad. Okay.
Unbeknownst to you, you were part of an experiment this afternoon. We decided to mix things up and take away PowerPoint, put our presenters out front without a table, without a podium, to have an honest conversation about not only their expertise, but their articulation of top priorities. We did our best to make this as interactive as possible, given the length of the room, and we want, in your evaluation of our session, for you to reflect whether that works for you and whether we should do that more. Please join me in a round of applause for our panelists. And I certainly did not want to neglect thanking Mary Kay Wimsett for this great idea. Thank you very much.